Good evening. You're watching The Urban Debate with me, Avni Raja. Over the next 1 hour, I'll bring you up to speed on the day's biggest stories combined with views and analysis. The Supreme Court strikes down a provision of the Benami law declaring it unconstitutional. Top legal voices will break down what it means and the implications of this. In Maharashtra, uproar in the assembly as BJP and opposition lock horns over farmers. This after a suicide attempt by a farmer outside the assembly. And we'll focus on the protests by TMC in Kolkata, reiterating their allegations of misuse of agencies by the centre. And a Times Network exclusive conversation with RBI Governor Shaktikanta Das also coming up. And let's get you the top story that we are tracking at this hour. In a significant order, the Apex Court has ruled that Benami Transactions Amendment Act is only prospective in nature and it cannot be applied retrospectively. The three-judge bench comprising of Chief Justice of India held that the 2016 amended act was prospective in nature. Supreme Court also ruled that the Section 3 of the amended Benami law is unconstitutional. To inform our viewers, Section 3 prescribed that whoever enters into any Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years or with fine or both. But to break this down, what it means and what are the implications, joining me on the show, Khushbu Jain, Advocate Supreme Court, and Ansh Singh Luthra, also advocate, joining us here on the broadcast. Thank you so much, both of you, for joining us on the show tonight. Let me, in fact, start with Khushbu Jain. If you can sort of break down, what decisions the top court has come to with respect to the Benami law.
Am I audible?
Yes, you're audible.
Perfect. So the new amendments, what today's Supreme Court decision specifically talks about, that it has said that certain provisions such as 3(2) of Benami Transactions Prohibition Act of 1988 is held unconstitutional, and also it went on the aspect of putting it that the laws cannot apply retrospectively. When I specifically talk about, see, there is a thing that there is a presumption against retrospective operation. So any act, anything which is being done or operated, if it does affect any legality past the transactions, then in this regard, retrospective transactions or operations of a statute cannot be done. And it's a golden rule that of a construction of an act. The golden rule of construction of an act, that it says that none of the act can be construed to have an effect which can alter the law applicable to the pending litigation at the time when the enactment was passed. So here what we're talking about is the act was old in 2016, the amendment came in. It had an impact on all the ongoing pending provisions, pending litigations, and also the rights of the people. Now, to understand more detail with regard to retrospective, no, it's not that retrospective amendments cannot be made, but specifically when we talk about which has penal provisions, retrospective application of those specific things are restrained. Now, if I quote, Supreme Court has repeatedly held in a plethora of judgments where they said that statute can be implemented retrospectively. However, such retrospective amendment cannot defeat the substantive rights of a party. Now I'm saying that substantive right of a party, and that's what is happening over here with the new act, that you practically did not bring a new act altogether. You did not scrape the old act and bought the new act, but you made amendments to the current act and started implementing the same provision, the new provisions in a retrospective manner. Now that retrospective had an impact on substantive impact on the rights of the parties. Is where the objection comes, that when there is which defeats the substantive rights of the party, those things cannot be implemented in a retrospective manner. Now, also, if you see that, any kind of amendments to a procedural law, which can be retrospective, but parties affected, how would the rights of those parties who are there, who can be affected substantially, their rights are taken away with, and the same thing is prohibited under the law, the same thing is prohibited by plethora of judgments by the Supreme Court.
Okay. All right. Ansh Singh Luthra, if you could also come in here and help us understand what does this effectively mean now going forward as far as cases that fall under this act are concerned.
Thank you, Avni. So what has happened today is that a constitutional affirmity has been done away with. Article 21 of the Constitution states that no ex post facto law, especially criminal, can be made. That means that no criminal law can have a retrospective application. As I'll further explain it for your viewers. For example, a crime is punishable with X offense in 2010. Therefore, in 2015, no amendment can be made which will make that crime be punishable with X plus 1. Number two, there is no place for any amendment, any criminal amendment in the garb of a civil or procedural amendment. Therefore, when you just simply say that an amendment is merely clarificatory or procedural in nature, though its intent might be criminal and its consequences might be criminal or have penal consequences, such an amendment cannot stand. So, no criminal amendment in the garb of civil law can stand. Let me try and explain what the government contended over here and how the Supreme Court has balanced the act and declared it unconstitutional. The government had essentially stated that the pre-amended act, the 1988 Act, had only 9 sections, whereas the new act has 8 chapters and 72 sections. And the government stated that this is merely a consolidating act since no machinery or procedure was in place, to give effect to the provisions of the previous act. Second, the government stated that the claimed amendment is only procedural in nature and therefore the bar against retrospectivity, which is in criminal law, does not apply. The third thing that was contended was that this act is come in so that no immunity should be granted to those persons who have been violating or continuing with Benami transactions since 1988, and hence this act should apply since 1988. However, the court has now held that the 1980 Act, in fact, I must tell you, 1988 Act itself was not retrospective; it was only prospective. It had come through an ordinance. More interestingly, Section 3, 5, and 8, which were not in the original ordinance, were made applicable from the date the 1988 Act came into effect. So, even in the previous Act, there was no retrospective application. Second, the new act enlarges, which is very important, enlarges the definition of Benami transaction. So it is not merely clarificatory. It gives 4 new categories of Benami transactions. It also talks about not merely transactions, but arrangement. It talks about transactions which are in fictitious names, where consideration paid is not traceable, which we also call sham transactions. And the fourth category is where the owner of the property itself is not aware or denies knowledge of the ownership. And hence the definition of the act itself is highly enlarged. Further, now there are mechanisms in place. Earlier, Section 5 of the previous act has been held arbitrary because there was no mechanism for defense. There was no standard of proof prescribed. There was no defense for an innocent owner. There was no provision with respect to vesting of acquired property. The government said that this act will clarify that and will put a machinery in place. However, this new act, which the Supreme Court has tested Section 5 on the ground of manifest arbitrariness and whether the nature is civil or of the penalty is civil or criminal. This was decided in Engel versus Netherlands. And when you see that the consequences of the amendment are criminal, therefore it cannot be merely retrospective. Such amendments have to be prospective. Similarly, Section 3(2) of the old Act has also been held manifestly arbitrary, not fair, not reasonable, not transparent, and hence the new Act, because the old Act had no mens rea in it, and therefore it has been held arbitrary. No mens rea means no intent. So even if you commit a Benami transaction without intent, you were punishable under the old Act. Now, the Supreme Court held that was arbitrary, struck it down. And therefore, since a new provision or a new offense is being created by this amendment, it cannot be retrospective and it has to apply from 1/11/2016 when the Act came into force.
Right, absolutely. And the other point that you mentioned, which was also important, is the fact that the intent aspect of which has been struck down as far as this new act is concerned. But Mr. Luthra, in this situation now, what is going to be the step forward in terms of sort of putting all of this together, including what the top court has said? Are we going to see sort of an overhauled law as far as Benami transactions are concerned?
What has happened now is that the authorities which have initiated actions or criminal prosecutions for transactions which have happened prior to 1/11/2016 when this act came into force will stand quashed. So those transactions go right out of the window. Number two, any further amendment which may come into play tomorrow will only have prospective effect. Therefore, anything that has happened prior to 1/11/2016 is no longer there, and no old offense or old transaction can be punished by this new amendment. Further, I must tell you, the Supreme Court has tried to balance this provision, which would have created very absurd kind of consequences had it not been quashed and had Article 21 of the Constitution not been upheld. Just to give you an example, you may know in Delhi there are so many illegal colonies where plots are transferred or cut and transferred on power of attorney basis. If this was not quashed, those transactions would also come into the net of Benami transactions and will have disastrous consequences for original owners or previous owners. So the court has tried to balance all of these aspects out.
Okay. All right. In fact, let me also here go back to Khushbu Jain. In terms of, cases that are currently ongoing, how would that then sort of proceed going forward?
It will have an impact because the cases after 2016, there were a lot of cases which challenged in the court that it cannot be applied retrospectively. All the matters which were being in process after that, they all had a challenge or a provision where say that this cannot be applied because this is arbitrary, this is going against Section 20 of Constitution, and penal provision cannot be applied retrospectively. Law has been very clear. So this is unjust and uncalled for, or this is arbitrary. Those provisions are there. So at least all those cases which are pending, which were initiated after the 2016 amendment that came in existence, all of them can take a benefit, and this order will have an impact on that. Now, there would be disruptions, yes, because a lot of proceedings have started and a lot of acts have been done, but this would have a clear-cut implication on all the pending matters, that none of those can go ahead, and retrospective applicable of things are not there. Going back to the aspect that why this was happening, I to an extent had. If you talk about law, yes, it cannot be done retrospectively, but one has to understand that why exactly it came into existence. If you'll see the original act of 1988, it came with the object of prohibiting Benami transactions. So if you look at, it refers to the transaction in simple terms, that is, where a person actually purchasing a property does not do so in his own name and does that in another person's name who is merely a name lender. To put a carb on it, this act came in existence. But if you look at the original act, it had just 9 sections, including the power of acquisition of Benami property by the appropriate authority, and also to prosecute offenders. But it also had an option in Section 8 where it said that central government can make rules, or it had to make rules under Section 8 to go ahead. But no such rules were being made till 2016. Therefore, the original act was widely regarded as toothless legislation, which though empowered the state to confiscate properties, but it was rarely used, and most importantly, no procedure, no rules, no mechanism were being prescribed to give effect to the provisions of the original act. Hence, in 2016, the new amendments came in existence. But I think when you bring substantive changes and you apply retrospectively, it has an effect, and that's where the situation today is. But yes, it will have benefit. Benefit will be given to all the pending cases since 2016.
All right, we leave it there. Thank you so much, Khushbu Jain and Ansh Singh Luthra, for joining us and breaking that down for us.